This content module is for CG13, the Judiciary, Part B. Demonstrate knowledge of the operation of the judicial branch of government, subparts C, D, and E. This portrait is of John Marshall, Chief Justice of the U.S. Supreme Court from 1801 until 1835. He wrote the judicial opinion for the court in the case of Marbury v. Madison, and is widely regarded as the architect of the Supreme Court's powerful influence on American government. The first peaceful exchange of power between political parties in the U.S. occurred after the election of 1800. The outgoing president, John Adams, appointed his Secretary of State, John Marshall, as the new Chief Justice of the Supreme Court. Marshall was confirmed by the lame duck Federalist-controlled Congress. This same Congress also passed the Judiciary Act of 1800, which added new positions for federal judges. Thus, President Adams could appoint Federalists to these new positions, with the lame duck Congress confirming them. The Democrat-Republican Party expressed outrage about these so-called midnight judges, and viewed the Federalist Party as unfairly trying to entrench partisan appointees in lifetime judicial positions. The new Congress and President Jefferson took office and promptly repealed the Judiciary Act of 1800 with the new Judiciary Act of 1801. The Supreme Court, led by Chief Justice Marshall, rejected a constitutional challenge to the repeal in Stewart v. Laird in 1802. Subsequently, a Federalist appointee, William Marbury, to a minor Justice of the Peace position in the District of Columbia, sued the Jefferson administration, claiming his legal right to this position. He demanded his commission of office and also sought his pay, dating to his confirmation by the Senate. Marbury sought a ruling by the Supreme Court ordering the current Secretary of State, James Madison, to release his commission and pay his salary or be held in contempt of court. Marbury v. Madison dealt with two constitutional questions. The first considered how the Appointments Clause to the Constitution should be interpreted, and the second addressed whether the Supreme Court's jurisdiction to hear Marbury's case under the Judiciary Act of 1789 conflicted with the U.S. Constitution's Article 3. In this case, the Supreme Court held that proof of an appointment that was made by the President and then confirmed by a majority vote of the Senate made an appointee an officer of the United States. On the second question, the court ruled that the Judiciary Act of 1789 unconstitutionally conflicted with Article 3 of the U.S. Constitution, and thus the court lacked the jurisdiction to hear Marbury's case. These pages are a surviving draft of the motion in the case. Officially, the U.S. government under President Jefferson took no official notice of the case. However, Chief Justice Marshall permitted a private citizen to represent the U.S. government in the case as amicus curiae, which means friend of the court. The court had to decide whether the Judiciary Act of 1789, Section 13, gave the U.S. Supreme Court the right to hear the case and issue a writ of mandamus, ordering Secretary Madison to release Marbury's appointment and salary. In a narrow reading of Article 3, Section 2, regarding the original jurisdiction of the Supreme Court, Chief Justice Marshall concluded the Judiciary Act of 1789, granting the Supreme Court the power of writs of mandamus, was unconstitutional. Writing the unanimous opinion, Justice Marshall held that Congress could not by legislation add to the original jurisdiction of the court from Article 3, Section 2 without a constitutional amendment. As the Judiciary Act of 1789 did not mention an alternative court to issue writs of mandamus, the case was dismissed permanently due to a lack of jurisdiction for any U.S. court to hear the case. There are several examples of judicial review before Marbury v. Madison. Alexander Hamilton, who wrote Federalist Papers dealing with the judiciary, was a strong proponent of judicial review and won a case in New York, Rutgers v. Waddington, using it. Later he used the same argument in Federalist 78 regarding the role of the judiciary. Before Marbury, in the case of Halton v. United States in 1798, the U.S. Supreme Court upheld a tax on carriages as constitutional, and justices implied they possess the power to declare a law unconstitutional as well. Including New York mentioned above, some state judiciaries also claim the power of judicial review prior to the new federal constitution, under their state constitutions. Ultimately, the political reaction to Justice Marshall's decision was muted at the time because Justice Marshall did not order his political opponents, Secretary Madison and President Jefferson, to do anything. Thus, there was little either could do in opposition when Justice Marshall dismissed Marbury's lawsuit. Due to the explicit supremacy clause in Article 6, Clause 2, there was little doubt that the Supreme Court of the U.S. has the power to declare state actions contrary to the U.S. Constitution, treaties, or federal statutes as illegal and unenforceable, and they did so in a Georgia case of Fletcher v. Peck in 1810. However, the use of judicial review at the federal level remains controversial, as no specific language exists granting this power in the U.S. Constitution. One controversial use of judicial review occurred in the case of Dred Scott v. Sanford. The court struck down multiple federal and state laws as unconstitutional regulation of slavery, including such foundational U.S. laws as the Northwest Ordinances and the Missouri Compromise. It even overturned its own precedents regarding territorial laws. This plaque in the U.S. Supreme Court building restates one of the more famous lines from John Marshall's opinion. It is emphatically the province and duty of the judicial department to say what the law is. Marbury v. Madison, 1803. SS CG13cde. Describe how the Supreme Court selects and decides cases. Originally, most cases came to the U.S. Supreme Court as either an appeal through a writ of error or appeal, or as part of the Supreme Court's original jurisdiction. Original jurisdiction cases are rare and average about one per year since 1789. Until the 1890s, appeals from lower courts represented most of the Supreme Court's workload. A formal appeal, under a writ of appeal or error, requires the Supreme Court to decide the appeal. These appeals create a binding legal precedent, and the Supreme Court's judgment in those cases is considered a legal right of the appellants. Appellants are those who want the court to overrule the lower court's decision, while those supporting the original ruling in the case are called appellees. Since the 1890s, Congress acted to reduce the Supreme Court's workload by restricting mandatory direct appeals to the court and allowing Supreme Court discretion to choose the remainder of its cases. To do this, Congress instituted the petition of certiorari. This requires those seeking review by the Supreme Court of their cases to petition the Supreme Court to grant a writ of certiorari. This writ orders the lower court to send the full record of the case to the Supreme Court for review. Certiorari petitions permit the court to consider a petitioner's and respondent's summary of the important facts and legal questions in the petition before agreeing to hear the case. Direct appeals require reading full case records that are often lengthy, and the court must give a decision on the case. With certiorari petitions, the court can fully investigate the legal issues involved in a few particular cases rather than struggling to hear and decide all appeals that often address the same issues. Petitioners are those who seek discretionary review of a case by the Supreme Court, and respondents are those who want the court to reject the petition and support the lower court's decision. Formal Supreme Court regulations regarding writs of certiorari are set forth in Rule 10. The court notes review on a writ of certiorari is not a matter of right, but of judicial discretion. A petition for a writ of certiorari will only be granted for compelling reasons. Such criteria include A. When the U.S. Courts of Appeal decisions disagree on the same legal question. B. When a lower court ignores Supreme Court precedent and the law. C. Disagreements between state Supreme Courts exist on the federal question. D. A conflict exists between state Supreme Courts and federal courts of appeal over a federal question, and E, an important federal legal question decided by the lower court requires the U.S. Supreme Court to issue a definitive ruling. Other considerations considering whether the court chooses to review a case. A, 4 justices ask for consideration of a case to be formally decided. B, the case is of critical importance. Time is an issue in the case, such as Bush v. Gore 1 and 2. C, support or lack thereof on the court that could affect victory or defeat of a judge's preferred legal policy. Other legal criteria for granting certiorari include legal considerations in the case of ripeness, mootness, redressability, and political question doctrines. Ripeness refers to the court's preference for a substantial body of decisions by lower courts with differing case facts and rationales. Mootness means the court only resolves current disputes rather than reviving old ones, and that an actual dispute exists between the litigants. Redressability means the litigants must seek a remedy that the court has the power to grant. Political question doctrine means, in a government of separated enumerated powers, some disputes are better resolved by Congress and the President through the political system. Formal legal considerations such as jurisdiction to hear the case and whether an individual has standing, which is suffering or will suffer a significant loss in a case, also matter. Judicial philosophies, CG13cde, compare the philosophies of judicial activism and judicial restraint and provide relevant examples. Strictly speaking, judicial activism refers to whether judges feel bound by the past decisions of the courts, the words of the Constitution or statute, or past tradition and custom regarding the role of the judiciary. Activist judges often believe injustices in society deserve a remedy instead of excuses for inaction. A judge that follows judicial restraint resolves cases based on the past decisions of the court, uses traditional interpretations of the words of the Constitution or statute, and follows past tradition and customs regarding the judicial role in our government. Those proposing restraint emphasize the limitations of the legal system and the judiciary to resolve questions best left to the voters and their representatives in executive and legislative branches. Complicating matters, there are two major approaches to interpreting the words of the Constitution. An originalist judge professes to be faithful and follow the original meaning of the U.S. Constitution. Some judges try to follow the original intent of the framers by examining past constitutional debates and writings. Other originalists, called textualists, seek to follow the specific text and how those words in the Constitution were commonly defined at the time of adoption. Non-originalism employs more varied principles, but generally focuses on the concepts underlying the U.S. Constitution, instead of the specific words or clauses of the Constitution itself. Non-originalists spend little time worrying about the framers' intentions or textual definitions. Instead, they embrace the title of living constitutionalist. For them, conflicts between the original words and interpretations of the U.S. Constitution and the desires of current society must be decided in favor of today's society. Others argue that the original document is stained by the inadequacies of the society and lawmakers that created it and should not be regarded as an authoritative source for current legal questions. Sources used for this content module. Sources used for images in this content module. Additional resources can be found at these websites. This concludes this content module.